Joining me on the DeMaio Report to unwrap some of the legal issues here is Seth Kaplowitz. He's a finance lecturer and attorney. Seth, thanks for joining us.
Well,
So the Apple computer company basically filed a First Amendment brief saying, look, we don't want the federal government to compel our speech. In other words, compel speech to write code. And for the rest of us, this is really a Fourth Amendment right and protection, which is we don't want the federal government to have the ability just to willy-nilly go through our papers and our cell phones, which is what this key would provide. But on the other side, you have people saying, well, this is security and the federal government has the right to do certain things to keep the public as a whole secure. Where do you think the law is going to come down on this?
it's hard to say where the law is going to come down. But as far as this case is concerned, there are basically two issues. The first one is whether or not the FBI's request sets a precedent. And the second issue is whether that precedent is a justified precedent. So I personally believe Apple is doing the right thing. I don't believe that the FBI should have the ability to force a company or an individual to create something in an effort to break through or manipulate something that is designed to protect the privacy of the information. I think that they're really walking very gingerly on eggshells with this. I can understand why they want it. I can understand why they don't want to guess because of the potential that if they do it 10 times, it's going to wipe out all the information in the phone. But I just don't see how the law should support this kind of action, because I think it's just going to open the door for more and more situations to try to utilize this approach.
All right. Thank you so much, Seth Kaplowitz, finance lecturer and attorney, for joining us on the DeMaio Report to talk a little bit about the legal issues.